Imagine you're holding a winning lottery ticket. You beat the staggering odds, right?
Yeah, every single number matches.
Exactly. You're standing at the counter, ready for your payout, but the clerk just shakes their head. You realize, like, you bought that ticket in a jurisdiction that simply refuses to honor it.
All based on some microscopic technicality you didn't even know existed.
Right. And that is exactly what winning a business dispute in Vietnam can feel like, if you do not map out your legal strategy from day one. Welcome to the deep dive. Today we are immersing you in the high-stakes, strategically complex world of business dispute resolution and debt recovery in Vietnam.
It is a really dynamic legal landscape.
Yeah.
And to make sense of it, we're pulling from a wealth of on-the-ground intelligence today.
Yeah, we have some incredible sources for this one.
We do. We're synthesizing strategic briefings on debt recovery from LTS law firm, practical arbitrator selection guides from the regional specialists at Tillich and Gibbons, and highly detailed procedural analyses from Zungzert and Associates.
The goal here is to really dig underneath that surface-level advice, right? To look at the actual mechanics of how foreign businesses succeed or fail when millions of dollars are on the line.
Exactly. The mission of this deep dive is to guide you through this strategic labyrinth. We're going to prove that winning a commercial dispute in Vietnam isn't just about having the indisputable facts on your side. It is about knowing exactly how, where, and with whom to fight.
Okay, let's unpack this, because before we even get into the weeds of legal loopholes and procedural traps, we have to talk about the very first crossroads every foreign company faces when a contract goes sour in Vietnam.
Right, the choice between litigation and arbitration.
The foundational choice.
Yeah.
So looking at the breakdown from LTF law firm, litigation in Vietnam takes place within the people's court system.
Specifically the economic courts, when we are dealing with commercial disputes.
Right.
And this is a very rigid, highly formalized environment. I mean, every single piece of documentation you submit has to be translated into Vietnamese.
And legally notarized, right?
Yes, completely notarized. Plus, you're required to pay these fixed upfront court fees that actually scale based on the total value of your dispute.
Which can get really expensive. And the proceedings are entirely public, meaning your business disputes are just out in the open.
Very public. And the timeline can be quite slow, often stretching 9 to 12 months just for a first instance judgment.
Right. But then you have arbitration, typically handled through institutions like the Vietnam International Arbitration Center, or VIAC.
Yeah, VIAC operates totally differently. It's a private process, generally much faster, around 46 months, and it offers flexibility in choosing your judges and your language.
But there's a catch, obviously.
Always a catch. It requires you to have a pre-existing arbitration agreement written into your original contract, and it comes with significantly higher initial costs for the arbitrator and the administrative fees.
So comparing these two is basically like choosing between taking a public commuter train and chartering a private helicopter.
That is a great way to look at it.
Right, like litigation is the public train. It operates on a fixed track. It stops at every single procedural station. Anyone can see you riding it. And the ticket is relatively cheap up front.
While arbitration is the private helicopter. You're going to pay a steep premium for it, but it's totally private, incredibly flexible, and theoretically flies you directly to your destination.
But I have to stop you here because the LTS law firm research highlighted a couple of real-world case studies that totally complicate this analogy.
It did, yeah.
They detailed a case where a Japanese equipment supplier used public litigation, the train, to win their dispute and effectively freeze the debtor's bank accounts in just 4 months.
That's incredibly fast for the courts.
Right. Meanwhile, a Korean logistics firm utilized private arbitration, the helicopter, and that process took 5 months. So if the clunky public train can actually get a company to the finish line faster than the expensive helicopter, I mean, why would a foreign business ever authorize the premium budget for arbitration?
Well, if we connect this to the bigger picture, the decision is rarely driven by speed alone. It's driven by the specific behavioral dynamics of the dispute.
Okay, what do you mean by behavioral dynamics?
So LTS Law Firm actually evaluates 4 distinct strategic factors before advising a client on this choice. First is simply contract readiness. I mean, if you didn't negotiate an arbitration clause on day 1, the helicopter isn't even fueled up. Litigation is your only legal avenue.
Right, that makes total sense. You need the ticket to fly.
Exactly. But the second factor is where that Japanese supplier's case becomes relevant, and that is debtor cooperation.
Ah, like if they're actively trying to hide money.
Precisely. If your debtor is actively evasive and you suspect they are quietly transferring funds out of their accounts, you need immediate aggressive state power.
And the courts have that power.
Yes. Vietnamese courts have the direct authority to issue preliminary injunctions, like freezing a bank account, far more swiftly and forcefully than an arbitral tribunal can.
Okay, so for the Japanese supplier, the court was basically a tactical weapon, not just a venue.
Exactly. They needed that brute force to secure the assets before they just vanished.
Wow. Okay, so contrast that with the Korean logistics firm. Why choose the slower, more expensive route?
That brings us to the third factor, the need for public deterrence versus private resolution. The Korean firm chose arbitration because confidentiality was their primary objective.
Oh, right, because they're in logistics. If word gets out that a major player is in a bitter public lawsuit over unpaid debts, clients might panic.
Exactly, they might pull their contracts.
Yeah.
Protecting their broader market reputation and ongoing business relationships made that slightly longer, 5-month private arbitration totally worth the higher cost.
That makes a lot of sense.
And the fourth factor is simply weighing urgency against cost. You have to balance the fixed upfront fee of the court against the potentially catastrophic financial cost of a 12-month delay if the court system gets bogged down with a massive backlog of cases.
Okay, here's where it gets really interesting. Because if you decide that confidentiality and control are paramount, and you shell out the money for the arbitration helicopter, you now have to select your pilot.
Yes, and that is not an easy process.
Based on the Tilek and Gibbons guide, you are essentially drafting a fantasy sports team. You're meticulously combing through stats, past performance, and specific skill sets, but your entire draft strategy can be derailed by real-world availability.
That's spot on. The arbitrator selection phase is arguably the most critical juncture of the private process. Tilek and Gibbons outlines a 3-step protocol for selecting an arbitrator for a Vietnam-ceded dispute.
Okay, what's step one?
Step 1 is having an intimate, granular understanding of your own case, knowing the exact technical sector, the complexity of the evidence, and the governing law.
So knowing exactly what kind of pilot you actually need.
Right. Then step 2 is assembling a candidate pool by researching institutional rosters, like VIEC's list, and evaluating the candidates' written decisions to gauge their analytical style.
Makes sense. But step 3 is where it gets tricky, right? The pre-appointment interview.
Yeah, step 3 runs into a uniquely local friction point. The source material notes that interviewing a judge before you hire them is a very tricky, novel concept in Vietnam.
Well, they just don't do it.
Well, in major international arbitration hubs like London or Singapore, reaching out to a potential arbitrator to verify their availability and ensure they have no hidden conflicts of interest is standard, heavily regulated practice.
Right, you'd want to know if they actually have time for you.
Exactly. But in Vietnam, the culture around this is still developing. Some highly qualified local arbitrators might actually refuse to speak with you prior to appointment out of an extreme abundance of caution regarding their perceived neutrality.
They don't want to seem biased before it even starts.
Right. And that brings us to the massive bottleneck you alluded to, availability. The source explicitly highlights that arbitration in Vietnam is rarely a full-time profession.
Wait, really? It's a side hustle.
Basically, yes. Your ideal arbitrator might primarily be a partner at a major law firm, a full-time university lecturer, or even a former government official. Arbitration is their side job.
So if you appoint this brilliant legal mind who simply does not have the calendar space to dedicate to your dense commercial dispute, you're stuck.
Your timeline will stretch agonizingly.
Let's play that out logically then. If the local arbitrator pool is mostly comprised of busy professionals doing this on the side and the local interview protocols are still murky, a foreign multinational is going to look at that and say, no thanks.
They might be very tempted to, yeah.
Right. Why wouldn't they just import a global heavy hitter? Bring in a famous full-time arbitrator from the International Chamber of Commerce in Paris, pay their premium, and guarantee a globally standardized process.
This raises an important question, actually, because what's fascinating here is how theoretical expertise collides with procedural reality.
Okay, how so?
Well, a towering figure in international arbitration, trained in the common law systems of the US or the UK, might be a procedural disaster in a Vietnam-ceded dispute.
Really? A disaster?
Tilek and Gibbons specifically cautions against bringing in foreign hotshots for local, lower-value disputes because of the inquisitorial style of Vietnamese proceedings.
Let's break that down because inquisitorial sounds like something out of a history book. What does that actually look like in a hearing room?
It's all about who drives the case. In a common law system, which most US and UK lawyers are used to, the judge, or arbitrator, plays an adversarial role.
Like a passive referee.
Exactly. They act somewhat like a referee, while the two opposing lawyers aggressively present evidence and cross-examine witnesses. The lawyers drive the case.
Okay, but Vietnam operates on a civil law system.
Right, with an inquisitorial style. This means the judge or arbitrator is expected to actively investigate the truth.
Oh, so they're down in the mud with the evidence.
Yes. They are the ones demanding specific evidence, driving the questioning of witnesses, and independently piecing together the timeline.
So if you bring in a common law superstar who just sits back and waits for the local Vietnamese lawyers to present the case.
And the local lawyers are sitting there waiting for the arbitrator to actively interrogate the evidence.
The entire process paralyzes.
Completely. Add in their unfamiliarity with local evidentiary practices and the nuances of the Vietnamese language, and that global expertise translates directly into massive procedural delays. You need a local guide who understands the unwritten cadence of the room.
It is the ultimate home field advantage issue. But let's assume you navigate the arbitrator selection perfectly. You find someone with the time, the local fluency, and the technical background. The game still might be over before the whistle blows.
Yes, because of the Vietnamese courts.
Right. They have the power to look at your beautifully crafted contract and declare that your specific dispute isn't legally allowed to be arbitrated in the first place.
This brings us to the arbitrability trap, detailed in the Zemzert and Associates analysis.
Arbitrability. It feels a bit like challenging a rival to a formal duel.
How so?
Well, you throw down the gauntlet, you hire the perfect second, you secure the private dueling grounds, and then the town referee steps in, checks the rule book, and announces that dueling is strictly prohibited for this specific category of insult.
That is a great analogy. Arbitrability is the foundational threshold. It asks a simple question. Does the sovereign law of Vietnam allow a private, non-state tribunal to decide this specific type of conflict?
And the answer isn't always yes.
No. Under the 2010 law on commercial arbitration, Vietnam did significantly broaden its definition of commercial activities to include investment and commercial promotion, which was a major modernization step.
But absolute limits remain. For example, tort claims.
Exactly. If someone negligently damages your company's physical property outside the bounds of a contract, you generally cannot arbitrate that in Vietnam unless a highly specific framework, like maritime or intellectual property law, grants an exception.
And real estate disputes are even more rigid. Those are the exclusive, non-negotiable domain of the Vietnamese state courts.
Yes, they are. But the trap that seems the most dangerous for international companies is what the legal analysis calls subjective arbitrability.
Oh, the hurdle of legal capacity. This is where countless foreign operations stumble.
Because it revolves around who exactly put their signature on the contract.
According to the source, branches, representative offices, or local business locations in Vietnam do not possess independent legal capacity.
They don't.
Wait, really? So, if the branch manager of a massive multi-billion-dollar multinational corporation signs a standard commercial contract with a local vendor, and that contract contains an arbitration clause,
A Vietnamese court could just throw the entire dispute resolution plan in the trash.
they absolutely can do that.
They absolutely can, and frequently do. To understand why, we have to look at the concept of a legal person under the Vietnamese Civil Code. A branch office is viewed merely as an operational extension of the parent company.
Okay, so it's not a distinct independent entity.
Right. It has no independent rights and liabilities. Therefore, the branch manager inherently lacks the capacity to legally bind the company to a private dispute resolution mechanism,
Unless what?
unless that manager possesses explicit, documented, and highly specific authorization from the parent company's ultimate legal representative to sign that exact arbitration agreement.
If they don't have that specific piece of paper, the clause is entirely void.
Entirely void.
That has to be terrifying for an international company running dozens of local branches. You could have hundreds of contracts suddenly stripped of their arbitration protections just because the wrong person signed the final page.
It really highlights a profound tension within Vietnam's legal infrastructure. The country is rapidly deploying modern commercial laws to attract global trade and facilitate international arbitration.
But those modern frameworks are built on top of very traditional conservative civil codes designed to protect state sovereignty.
Exactly.
Yeah.
Take the doctrine of state immunity under the 2015 Civil Code, for example. If a foreign investor is entering a joint venture with a Vietnamese state-owned enterprise or government agency, that state entity is generally immune from being dragged into private arbitration.
Wow, so they can just opt out.
Essentially, yes. The only way around this is if the state entity explicitly waives its sovereign immunity within an international treaty or the specific contract.
So it requires a level of extreme precision from day one.
Exactly, because the underlying legal architecture defaults to protecting the state's authority.
Okay, so assuming your contract is watertight, your dispute is arbitrable, you found an available locally fluent arbitrator, you survive the hearings, and the tribunal awards you a massive payout.
You are holding the winning lottery ticket.
Exactly. Time to finally cash in, right? Not so fast. The Zumster and Associates analysis introduces what I like to call the final boss of this entire process.
Yes, convincing the Vietnamese courts to actually enforce and execute that foreign arbitral award.
Right. So enforcement is governed globally by the 1958 New York Convention.
The bedrock of international trade. It allows a business to win an arbitral award in one country and enforce it against assets located in another.
But the convention was drafted with safety valves, the most notorious being the public policy exception.
Right, a sovereign nation can refuse to enforce an international award if executing it would fundamentally violate that nation's public policy.
But the text points out that when Vietnam integrated the New York Convention into its own legal system, it translated the concept of public policy into a phrase roughly meaning the fundamental principles of Vietnamese laws.
And that subtle shift in translation created an incredibly broad, vague loophole that losing parties aggressively exploit to annul awards.
Because the phrase fundamental principles lacks a strict, exhaustive definition in the statutes.
Exactly. Because of this ambiguity, domestic companies that lost in arbitration began arguing to the Vietnamese courts that any minor technical breach of a local regulation committed by the foreign company during the course of business constituted a breach of a fundamental principle.
And the courts actually bought that.
Often, yes. The Supreme People's Court eventually tried to rein this in with Resolution 01 in 2014, instructing judges that this exception should only apply to overriding basic principles of conduct things akin to outright fraud, coercion, or severe violations of constitutional rights.
But examining the case studies from the sources reveals how elastically local judges still interpret this.
The case studies are truly eye-opening.
They are mind-blowing. Look at Tyco versus Leighton. Tyco wins a major arbitration down in Australia. They bring their legally sound award to Vietnam to seize assets.
And the Vietnamese court reviews it and outright refuses enforcement.
Right. Why? Because Tyco, a foreign entity, did not possess a specific Vietnamese construction contractor license while doing the work.
And then consider the Topfer versus Sao Mai case.
Right. An international commodities tribunal issues an award in favor of Topfer based on standard global agricultural trade rules.
But the Vietnamese court rejects it.
Because the damages calculated by the foreign arbitrator were not proven as actual and direct under the rigid, specific lens of Vietnamese commercial law.
It's a very strict standard.
So what does this all mean? Honestly, it feels exactly like beating a notoriously hard video game. You memorized the enemy patterns, you flawlessly executed the strategy, you beat the final boss.
And right as the credits are about to roll, the console unplugs itself.
Yes. Because the internal hardware decided you didn't hold the controller the right way. So does this mean the Vietnamese court system is simply using this translation loophole as a veil of protectionism to shield their local companies from paying out foreign judgments?
It is very tempting to look at those rulings and cry protectionism. But a deeper analysis of the legal architecture suggests something else entirely.
Okay, what is it then?
This is less about malicious protectionism and more about a profound clash of legal mentalities.
Civil law versus common law again?
Exactly. Vietnamese judges operate within a strict, statutory civil law system. Their primary sworn duty is to uphold the literal text of the national code.
So they aren't looking at the spirit of the law, just the letter.
Right. When a foreign arbitrator operating under fluid, common law concepts like foreseeability of damages hands down an award, it often conflicts with Vietnamese civil law.
Because civil law demands that every single dollar of a loss be rigidly proven with invoices as actual and direct.
Precisely. In the Tyco case, the judges didn't just see a missing piece of paper. They viewed operating without a local contractor license as a deliberate evasion of Vietnamese state tax structures.
Ah, I see.
To a civil law judge, bypassing state regulation is a violation of a fundamental principle of how society is governed.
Okay, that makes sense from their perspective. But the Zungcert and Associates text highlights a truly bizarre quirk in how Vietnam even defines a foreign award in the first place, which just exposes so many more cases to this scrutiny.
Yes, the nationality of the award.
This is one of the strangest technicalities in the entire briefing.
It is entirely unique to Vietnam's law on commercial arbitration. In the vast majority of international jurisdictions, an arbitral award is considered foreign based on its physical seat.
Like, if the hearings happen in Paris, it's a French award?
Exactly. But in Vietnam, the nationality of the award is determined by the governing law of the arbitration center.
Wait, so you could hold your entire arbitration in a hotel conference room in downtown Ho Chi Minh City.
Both companies could be based in Asia.
But if your contract dictates that the arbitration is administered under the rules of the International Chamber of Commerce, the ICC, headquartered in Paris,
Vietnam legally classifies that as a foreign award.
just because of the rules you used.
Yes, and because of that classification, you cannot simply execute it locally. You are forced to drag it through the grueling, complex New York Convention recognition process.
Throwing yourself right back into the crosshairs of the fundamental principles trap. That is a staggering technicality. So a company thinks they're playing a local game, but the referee treats them like an invading force. With all of these massive structural hurdles, I mean, is there any good news for foreign operators?
The sources do point to some modernization efforts. There's a vital tactical shift happening on the administrative side.
Largely driven by the updates in the 2015 Civil Procedure Code, right?
Yes. Historically, the sheer bureaucracy of enforcing a foreign award was a nightmare. Everything had to be routed through the Ministry of Justice, which added months of opaque administrative layering.
But the 2015 updates changed that.
They did. The updates allow foreign companies to bypass the Ministry of Justice completely. You can now submit your request for recognition directly to the competent provincial people's court.
Assuming no specific bilateral treaty like the ones Vietnam holds with China or France dictates a different route.
Right. Always check the treaties.
So this looks like the TSA pre-check line of the legal system. Instead of showing up to the court with a massive suitcase full of complex legal arguments, the paperwork requirement is drastically reduced.
Drastically. The Zungsert and Associates analysis notes that a standard civil claim in Vietnam demands 7 different categories of evidence to even prove a case.
But if you're holding an arbitral award, you only need 3 things.
Just 3. The original or certified copy of the award, the original or certified arbitration agreement, and perfectly legally notarized Vietnamese translations of both. That is it.
Okay, but let me view this through a slightly more cynical lens here.
Go for it.
If a company still has to prove their branch manager had the precise legal capacity to sign the document.
Which we know is tough.
Right, and they still have to acquire flawlessly notarized translations.
Also tough.
And they are still ultimately subject to a judge reviewing the case against the fundamental principles of Vietnamese law. Is this an actual fast track? Or is the government just creating a slightly shorter line for the exact same terrifying roller coaster?
What's fascinating here is the power of international signaling.
Yeah.
You are completely correct that the substantive legal hurdles, the capacity traps, the fundamental principles review, they're all still very much alive.
The roller coaster hasn't changed its tracks.
Exactly. But explicitly uncoupling the enforcement of foreign arbitral awards from the standard, cumbersome domestic civil procedure is a massive signal from Hanoi.
A signal to who?
To the international business community. By reducing the administrative friction from 7 categories of evidence down to 3, and surgically cutting the Ministry of Justice out of the routing process, the government is demonstrating to global investors that it wants to honor the spirit of the New York Convention.
So they're trying to reduce bureaucratic friction, even if the judges themselves are still strict.
Exactly. The judicial mindset of the local judges will take generations to fully evolve away from strict civil code protectionism. But the state is actively building the bureaucratic infrastructure to make global trade more efficient today.
It is an ecosystem in active transition. So to pull all of these threads together, doing business in Vietnam means treating your dispute resolution clause as a day-one strategic priority.
It is not just boilerplate text you ignore until something breaks.
Exactly. You have to actively evaluate whether your specific crisis requires the public commuter train of the economic courts to freeze assets or the private helicopter of arbitration to protect your reputation.
And if you charter the helicopter, you have to carefully vet a locally fluent arbitrator rather than importing a global superstar who will clash with the inquisitorial system.
You must survive the arbitrability trap by ensuring the person signing your contract actually possesses independent legal personhood.
And finally, mentally prepare to defend your victory against the fundamental principle's final boss when you seek local enforcement.
Right. In this rapidly shifting environment, deep technical preparation isn't just a best practice, it's your ultimate armor.
And this raises an important question regarding the future of that environment, actually, driven by a provocative development mentioned at the very end of the Dung Certain Associates material.
Oh, right. The landscape we just discussed is about to undergo a seismic shock, isn't it?
Huge, due to the EU-Vietnam Free Trade Agreement, or EVFTA.
Okay, what does the EVFTA do?
Under the frameworks of EVFTA, after a 5-year transition period, decisions handed down from the newly established investment court system will be automatically recognized as final, enforceable judgments within Vietnam.
Wait, automatically?
Automatically. They completely bypass the New York Convention recognition process.
So there's no Ministry of Justice routing and absolutely no fundamental principles review by a local civil law judge.
Absolutely none.
Wow. So if mega investors and massive multinational corporations are granted an automatic, skip-the-line pass that entirely sidesteps the local judiciary's protectionist instincts, what happens to the rest of the market?
That is the big question. Will standard commercial arbitration, with all its traps and translation hurdles, become a relic of the past for standard businesses?
Are we actively watching the emergence of a two-tier justice system in global trade, where the largest players operate completely immune from the local legal realities that everyone else must fight through?
It's certainly starting to look that way.
That is a heavy, fascinating thought to leave you on. The rules of the game are clearly changing, and the value of that winning lottery ticket might soon depend entirely on who exactly is standing at the counter trying to cash it in. Keep checking the fine print on your contracts, stay curious, and we will see you next time.